officials. But such is not the case. The legislature or Congress never envisioned a situation where, in the process of allowing foreign currency deposits and its depositors to claim confidentiality, will be resulting in violation of the law on, for instance, smuggling, on kidnapping with ransom, and so on down the line. Now, secondly, it is very clear now, under the AMLA law as amended, that the confidentiality enshrined under the AMLA law, under Republic Act 6426, may no longer be invoked if the prosecution, Your Honor, is a prosecution for any of the transactional offenses enumerated under the AMLA law. In other words, it is another exception whereby the depositor may no longer avail himself of what is known as foreign currency deposit, Your Honor. Now, I was amazed by the peroration of my learned colleague who had spoken before us, Your Honor, to the effect that allegedly there are a lot of falsities, a lot of lies permeating the declaration of the Honorable Chief Justice. I wanted immediately to agree with him, but his behavior before and during the presentation of the evidence or declaration by the Chief Justice does not approve of such kind of a plea, Your Honor. Why? Because Chief Justice Corona was here. He was available for cross-examination. If they doubted the credibility of Justice Corona, they should have taken advantage of the opportunity to cross-examine him. But it is on record, Your Honor, that there was no such cross-examination. In fact, it was categorically and positively waived by the lead counsel of the prosecution, Your Honor. And for that, we were heavily thankful because it shortened the stand activity of Chief Justice Corona, Your Honor. Now, they likewise referred to a lot of fabricated lies, Your Honor, more especially with respect to alleged buying of dollar deposits and so on. There is no statement on record, Your Honor, by the Chief Justice Corona that he started buying when he was still an undergraduate, continuously up to the point that he accumulated the amount that he admitted before this honorable court. I would like to commend Chief Justice Corona because notwithstanding several advices during the conferences that we had, that it is his right not to testify because no evidence, he cannot be compelled to testify, these proceedings being akin to a criminal case, he still insists on bringing before this court an admission to the effect that he has so much, that he has so much. He should be commended for that matter, Your Honor. But what is his explanation? Let me go a little further. What is the allegation with respect to the non-entry into the SAL of the Chief Justice Corona of the various properties alluded to by the prosecution, consisting of 45 pieces of properties? Little by little, Your Honor, while the trial goes on, we were able to show, I believe to the satisfaction of this honorable court, that there were no 45 pieces of properties and that ultimately there were only 5. That is why the other properties, which do not belong to him and which are registered in the name of persons whom he does not even know, need not be accounted for by him in the SAL that he filed for that matter. Now, he is also being charged or blamed or flawed because allegedly there were acquisitions made by him on a particular year, but they were not registered on that year, and they were registered later for a year or 2 years thereafter. We have no quarrel with that. Even our evidence show that there is some violation on the part of the family of Chief Justice Corona because there were some doubts as to the validity of the transfer of the ownership to him. And therefore, his non-reporting may not be considered as intentional, fraudulent, malicious, and be the subject of an impeachment proceedings, Your Honor. Now, there were statements made here in connection with an employee, a law employee of the Department of Supreme Court of Justice relative to certain acts committed by him or her. But that cannot be equated. There is no parity of facts between that case and this case. That is merely an administrative case. This is an impeachment case, Your Honor, governed by the provisions of the Constitution and grounded on definite and specific grounds, Your Honor. Namely, culpable violation of the Constitution, treason, other high crimes, violation of the anti-graft law, and betrayal of public trust. May we ask the prosecution, Your Honor, whether there is any jurisprudence on the point that a mere deficiency or a mere inaccuracy in the entries made by a filer in the SAL is constitutive of a ground for impeachment which they claim now. I do not think, and I am not aware, I will be heavily thankful, Your Honor, and be fully appreciative if they can enlighten, because this happened to be my forte in criminal law, which is still my forte, being a member of the faculty of the University of the Philippines College of Law, Your Honor. Now, if it is not an impeachable offense, Your Honor, if it cannot be a ground for impeachment, then why are we building up matters after matters to the prejudice not only of the life, the honor, and the reputation of the Chief Justice, but his entire family, which even after years may no longer be erased or obliterated because it's already sunk into the minds of the common people, being the subject of what we call conferences even outside of this court, Your Honor. Now, let me go a little further, Your Honor, with the kind permission of this honorable court. There is a statement here made by the Honorable Ombudsman relative to the properties and deposits and cash deposits and accounts, Your Honor, which he declared while on the witness stand. Unfortunately, Your Honor, when we cross-examined her, she was truthful in admitting that there are no charges at the time filed against Chief Justice Corona. He is not a respondent nor an accused in any crimes mentioned under the AMLA law, but that pursuant to his general power as Ombudsman, she conducted the investigation on the strength of the affidavit complaint presented or submitted by several persons, Your Honor. These are the persons we introduced in evidence. We called them to testify in order to prove our contention that none of them had mentioned the existence of the $10 million account referred to in the report of the Honorable Ombudsman, Your Honor. Now, in order to justify further her statement on the matter with respect to properties and deposits, Your Honor, she waived certain papers, Your Honor. Allegedly, they were entries or they were papers, Your Honor, furnished her by the anti-laundering council, Your Honor. Now, at first, I was almost convinced that there is validity in her assertion, Your Honor. But when we examined the documents, Your Honor, and we were permitted by the court to do so, we found out that there was no proper attestation. There is only an initial, but we do not know whose initial they are. The question is that admissible in evidence? Our answer is no, because if it is not properly authenticated, then it is violative of Section 25, Rule 132 on evidence. And what does it say? May I be permitted to read the same? Whenever a copy of a document or record is attested for the purpose of evidence, the attestation must state in substance that the copy is a correct copy of the original or a specific part thereof, as the case may be. The attestation must be under official seal of the attesting officer, if there be any, or if he be clerk of court having a seal under the seal of said court. We notice, and we gather upon the examination of those documents, Your Honor, I hope I am pardoned by the court, that they are mere scrap of paper, that attestation required by law is not present, and therefore they are not admissible in evidence. If they are not admissible in evidence, what probative value that is says? I hope the court pardon me by saying it is totally useless, it is totally irrelevant to the matters brought about by her. Now, there were also statements made by the witness, by her, to the effect that these papers were allegedly furnished to her by the AMLA people, Your Honor. That allegedly was furnished here by the official of the AMLA, Your Honor. Some members or our colleagues in the legal profession say, why did you not call the AMLA people to contradict that they never have furnished her? That is not the job of the defense, Your Honor. The position here of the Chief Justice is akin to an accused in a criminal case. The general presumption enshrined under our Constitution that he enjoys the privilege of being an innocent or innocent of the crime which is attributed to him holds water. He is not under legal obligation to prove his innocence, Your Honor. It is the burden of the prosecution in this particular case, the prosecution, to prove that his guilt, and that is failure to indicate or enter into his son the required matters that ought to be stated in there. I have not seen yet any document to the effect that a failure to state in a son, Your Honor, on the part of the filer, especially impeachable officers, could be a ground for impeachment, Your Honor. Impeachment must be treated with caution, must be treated circumspectively, and not haphazardly or done as our government officials of the opposite persuasion may claim, Your Honor. And that brings me to the matter of, although I'm a little bit reluctant, Your Honor, our challenge against the validity of the impeachment complaint in this particular case. Why? Because when we examine the documents attached to the complaint, Your Honor, more particularly to the signature and verification and certification, we find nothing in there which states that the 188 members of our House of Representatives whose signature attached there were convened at any time prior to the certification in order to pass upon the probable cause aspect of the complaint, Your Honor. I hope, and in this connection, Your Honor, we are in total conformity with the jurisprudence on the point, more especially by the ponencia of Chief Justice Panganiban, Your Honor, where it... Sandon. On the issue of observance of due process during the initiation of impeachment, Your Honor. May I be allowed to read in part, Your Honor, for purposes of having them entered into the record. Fourth, during the oral argument, Senator Salonga and Petitioners Francisco Chavez denounced the second impeachment complaint as violative of due process. They argued that by virtue merely of the endorsement of more than one-third of the members of the House of Representatives, the Chief Justice was immediately impeached without being afforded the twin requirements of notice and hearing. The proceedings were therefore null and void. And the Justice Panganiban then, who became Chief Justice, I said, I must agree. Going further with his ponencia, Your Honor, he further laid down the following dictum. The due process clause, Article 3 of the Constitution reads, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws enshrined in our Constitution, is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial or otherwise, citing Justice Mr. Bernas, the commentaries, and several cases, Your Honor. It is deemed, according to him, written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charge official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. Along this line, Your Honor, may I also bring to the attention of this Honorable Court the concurring opinion on the same subject, Your Honor, by the retired Justice Inares Santiago. And it runs this way, Your Honor. The impeachment complaint suffers yet from another serious flaw. As one of the amicus curiae, former Senate President Salonga pointed out, the signing of impeachment complaint by the purported one-third of the congressman was done without due process. The Chief Justice, against whom the complaint was brought, was not served with notice of the proceedings against him. No rule is better established under the due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his right. Indeed, when the Constitution says no person shall be deprived of life, liberty, or property without due process of law, it means that every person shall be afforded the essential element of notice in any proceeding. Any act committed in violation of this due process must be declared null and void. With the citation, Your Honor. Now, I brought home to the attention of this Honorable Court, Your Honor, this particular jurisprudence on the point, because if we follow the proceedings that attended the filing of this case, Your Honor, I hope the prosecution and the government will pardon me for saying it. To us, although we may be charged as biased, Your Honor, we noticed the blitzkrieg maneuver that accompanied or clothed the filing of this information. True, there were allegedly a point presentation by the Honorable Lead Counsel at the time of the meeting of the congressman who signed the 188. But we do not notice any statement, or the statement relative to verification and certification is totally bankrupt of any statement to the effect that they assembled, they discussed this matter, and it was only after determining that there was really notice and proper opportunity for investigation was made that they came to the filing of this case and so on. My point is this, Your Honor. The number of the complainant, whether they be more than 200 congressmen affixing their signature, assuming their signature, the affixing of their signature, were voluntary and personal. That does not nullify the provision on due process, because it is a time-honored principle of our Constitution that no person shall be deprived of life, liberty, or property without due process of law. Now, if the impeachment complaint is filed by only by a member or by a private citizen with the endorsement of a member of the House of Representatives, the procedure enshrined is it must be acted upon by the Committee on Justice. There must be deliberation, and whatever the result of the deliberation, it is presented before the House in plenary session. Those are the only things that were dispensed with if the information or the impeachment complaint is filed by more than one-third of the members of the House, Your Honor. With that, we rest our case, Your Honor. We only pray, Your Honor, na sa amin pong pagdulog sa kagalang-galang na hukumang ito sana po dumulog po kami sa poong may kapal. Hiniling namin kung maaari, tanglawan po ninyo ang pag-iisip, ang puso at damdamin ng mga senador na huwes na hahatol sa kasong ito. Sana po, umira lang buong Katarungan sa ikaliligaya, hindi lamang ng impeachment court, hindi lamang ng nasa sakdal, kundi ng buong Republika ng Pilipinas. At sana po, ito'y maging mitya na para magkasundo-sundo ang buong nagkakaalit at lumigaya ang buong Pilipinas. Salamat po ng marami, Chief Justice.
Okay.
Justice.
Session suspended for 2 minutes before the
Before the closing of the prosecution.
before the closing.